बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलाम वालेकुम। एक बार फिर से मैं डायनेमिक लॉ एसोसिएशन की जानिब से आप सभी को खुश आमदीद करूँगी। उम्मीद है कि आप सब खैरियत से होंगे, खुशबाश होंगे। और यकीनन आज भी ये सेशन आपने इसलिए ज्वाइन किया होगा कि आपके जहन में ये सोच होगी कि आप कुछ सीख कर कुछ सीख कर और कुछ समझ कर इस सेशन से उठेंगे हमेशा की तरह। और बिल्कुल डायनेमिक लॉ एसोसिएशन की भी हमेशा से ये कोशिश रही है कि लॉ के तालिब इल्म और जो नौजवान वकला हैं उन तक वो इल्म पहुंचा दिया जाए जो दर हकीकत हमारा जो लॉ का दौरानिया है, जो हमारा 5 ईयर प्रोग्राम है, उसका जो सिलेबस है उसमें ये चीज़ मुमकिन नहीं हो पाती। और कहीं न कहीं हमारी जो लॉ की फ़ील्ड है, हमारी सोसाइटी से रिलेट करती है। और जहाँ सोशल इश्यूज़ बढ़ते हैं, हमारी सोसाइटी में चेंजिंग आती है, तो हमारी लॉ में भी तब्दीलियाँ आती हैं, कवानीन में भी तब्दीलियाँ आती हैं, नए कवानीन बनते हैं, उनमें तरामीम होती हैं। और वक़्त की ज़रूरत के साथ-साथ नौजवान वकला को और लॉ के तालिब इल्म को उसको समझने की और सीखने की ज़रूरत रहती है। इसलिए कहा जाता है कि वकील के लिए जो है लिखना और पढ़ना हमेशा का उसका साथ है। आज के इस सेशन का जो है बाकायदा हम आगाज़ करेंगे। एक बार फिर से मैं आपको वेलकम करूँगी और हमारे जो आज के सेशन का टॉपिक है, वो है लीगल इश्यूज़ सराउंडिंग द यूज़ ऑफ एआई इन लीगल प्रोफेशन। आपने एआई का नाम ज़रूर सुना होगा अगर आप सोशल मीडिया सारिफ हैं या अगर आप किसी भी इस तरह के प्लेटफॉर्म का यूज़ करते हैं जिसमें आपको डिजिटल नॉलेज की या डिजिटल हेल्प की ज़रूरत होती है, तो आपने एआई का सहारा ज़रूर लिया होगा। और अगर आप सोशल मीडिया सार्फ हैं तो आपने कहीं ना कहीं एआई वर्चुअल फ्रेंड भी अपना रखा होगा। अगर आप स्नैपचैट यूज़र हैं तो वहाँ से भी आपने इसको ज़रूर एक्सपीरियंस किया होगा। लेकिन आज हम उस स्नैपचैट एआई की बात नहीं करेंगे, आज हम बात करेंगे एआई जो कि हमारी फील्ड में, लीगल फील्ड में मुतारिफ कराया गया है। तो इसके क्या प्रोस एंड कॉन्स है, इस हवाले से हम बात करेंगे। अगर एआई टूल की बात की जाए तो इसमें डिफरेंट किस्म के टूल्स हमारे पास मौजूद हैं, जिसमें एनएलपी टूल है, कंप्यूटर विजन है, वर्चुअल असिस्टेंट है जिसकी अभी मैंने बात की, रोबोटिक टूल्स हैं, चैट जीपीटी है और एक्सेट्रा एक्सेट्रा। लेकिन से ये मुस्तफ़ीद हमसे हो सकते हैं और इसके हवाले से क्या लीगल इश्यूज़ हैं, हम इसके हवाले से आज बात को थ्रेट कर रहे हैं। कहीं न कहीं ये ह्यूमन राइट को थ्रेट कर रही है क्योंकि जहाँ एक लॉ चैम्बर में, लॉ की फर्म में हम लीगल ड्राफ्टिंग के लिए या राइटिंग जिसकी स्किल्स अच्छी होती हैं उनको हायर किया जाता है कि वो अपनी लीगल असिस्टेंट प्रोवाइड करें। तो वहाँ पर हम अगर एआई का सहारा लेंगे तो हो सकता है कि ह्यूमन जॉब को इससे खतरात लाहक हों। साइमल्टेनियसली इस स्टडी में ये भी जो है कहा गया है, इस रिसर्च के मुताबिक जो कि प्रेस्टिजियस इंस्टीट्यूशन ने की है, उसमें ये भी मेंशन है कि लीगल सेक्टर को हाल ही के कुछ सालों में बहुत ज़्यादा जो है एआई की तरफ से ग्रेट इम्पैक्ट्स मिले हैं और कुछ ऐसे लीगल इश्यूज भी फेस करने को मिले हैं जो शायद पहले नहीं थे। इसी के साथ ही न्यूयॉर्क के एक लॉयर स्टीवन शेवर्स ने अपने एक्सपीरियंस को जो है शेयर किया इस रिसर्च में और बताया कि जब उन्होंने एआई का सहारा लेकर, स्पेशली चैट जीपीटी का सहारा लेकर अपने एक केस के सिनेरियो को डिज़ाइन किया, तो उन्हें डिसिप्लिनरी एक्शंस जो हैं फेस करने को मिले। और शॉकिंगली इस रिपोर्ट के मुताबिक हर 7 में से 6 केस जो एआई से तैयार किया जाता है वो फैब्रिकेटेड होता है और जिसका हकीकत से या फिर रियल फैक्ट एंड फिगर से कोई ताल्लुक नहीं होता। लेकिन क्या ये सिर्फ मिथ है या फिर हकीकत से इसका कोई ताल्लुक है? क्योंकि हम देखते हैं कि रिसर्च वर्ल्ड में जो हमारी रिसर्च है वो तब्दील होती है। ये 2021 की रिपोर्ट है और इस वक्त हम 2024 में जी रहे हैं। तो आज के स्पीकर से हम जानेंगे कि क्या तब्दीलियां आई हैं रिसर्च में और दरअसल एआई किस तरह से हेल्प कर सकता है और क्या प्रोस एंड कॉन्स हैं और क्या लीगल इश्यूज हैं हमारे एआई को यूज़ करने में। आज के हमारे स्पीकर हमारे साथ इस वक्त मौजूद हैं सर गुलाम असगर पठान साहब, जिनका ताल्लुक जो है कराची सिंध से, जो एक वेल इन्फॉर्म, एक रिप्यूटेड लॉयर के नाम से जाने जाते हैं। अगर इनके एरिया ऑफ प्रैक्टिस की बात करूं तो ये किसी तारीफ के मोहताज नहीं है, ना सिर्फ सिविल एंड फैमिली लॉज, क्रिमिनल लॉज, बल्कि इंटरनेशनल, कस्टम, एंटी टेररिज्म लॉ, बैंकिंग, इनहेरिटेंस और एग्जेक्ट्रा एग्जेक्ट्रा मुख्तलिफ फील्ड में इन्होंने जो है अपना किरदार निभाया है। और अगर मुकादे आमा की अगर मैं बात करूं तो ये इन्हीं की मरहून मिन्नत है कि आज डिस्ट्रिक्ट कोर्ट की जो हमारी पीक्यूनियरी जुरिस्डिक्शन है वो 15 मिलियन से 65 मिलियन तक जो है इन्हांस्ड कर गई है। और 2018 की एक CP 59113 में जो है हाई कोर्ट ने इनके इस अमल को काफी सराहा, जिसमें हाई कोर्ट के रिमार्क्स हैं कि इस काविश के बाद कमर्शियल कोर्ट की जो कॉन्स्टिट्यूशन या एस्टेब्लिशमेंट है उसमें कंज्यूमर सार्फिन को बहुत ज़्यादा आसानी रही है उनके केस से निपटने के लिए, क्योंकि जो ये एनहांसमेंट और सर असगर पठान के साथ की जानिब से जो ये काविश रही है और उनकी जो मेहनत है। तो मैं बाकायदा वेलकम करूंगी हमारे आज के स्पीकर सर गुलाम असगर पठान साहब को, अगर वो हमें सुन रहे हैं, कि वो आएं और अपने ख्यालात का इजहार करें एआई के हिसाब से, कि एआई किस तरह से जो है वो हेल्प कर रहा है लीगल इश्यूज को, और किस तरह से जो इसके प्रॉस एंड कॉन्स हैं, और हमें जो है एडवांस जो है नॉलेज के बारे में बताएं। जी अस्सलाम वालेकुम सर।
जी अस्सलाम वालेकुम। थैंक यू फॉर द ब्रीफ इंट्रोडक्शन। जिस तरह मैडम ने अभी इंट्रोडक्शन दिया है, मैं इस वक्त जो है करंटली जॉइंट सेक्रेटरी हूँ सिंध हाई कोर्ट बार एसोसिएशन का, एंड आई एम हेडिंग द लीगल एजुकेशन कमिटी एज वेल. So for today's topic, that is artificial intelligence in the legal profession in Pakistan. Uh, जो सबसे बेसिक एक इशू है वो ये है कि हमारे यहाँ जो बड़ा एक चैलेंज है वो ये है लैक ऑफ रेगुलेशंस का. We have seen that there are so many reports and work has been done internationally in various jurisdictions upon the subject of artificial intelligence. But we have not been able to demonstrate any such capability or the competence to deal with these kind of things in the legal profession. उसकी सबसे जो अहम एक वजह है वो है the lack of proper regulation by the bar councils, those who regulate the legal profession. और उसी की वजह से मैं ये समझता हूँ कि हमारे यहाँ बातें तो कई सारी सुनी जाती हैं कि आर्टिफिशियल इंटेलिजेंस या जिस तरह कुछ सॉफ्टवेयर्स हैं जिनको यूज़ करके इस्तेमाल किया जा रहा है, और कभी ना कभी केसों के डिसीजन के हवाले से आप सब खबरें भी सुनते होंगे. So the first thing that I would say that is not well regulated or even regulated in our country. But before getting into it, I will start with the issue of what the artificial intelligence would mean in the in the ordinary perspective. So this is something a software where we provide data to that software for the learning purposes. So इसमें लाखों की तादाद से जो decisions हैं वो इस मशीन में एज एन इनपुट इन्वॉल्व किए जाते हैं for the purposes so that in future when this software would come up with the same kind of situation, would share would share its decision or its prediction about the situation on the basis of information that has previously been shared in the software. So even when we talk about artificial intelligence softwares, we do not ignore the human input in any software, because it is we the human who would provide all these material for the machine or the software to learn before giving any predictions about any situation. And when we see that we have given various decisions to the software, it will come up with these ideas or the predictions that what the solution of any situation would be. And the pattern for the artificial intelligence is a threefold thing. First, based on learning, reasoning, and of its own self-correction. Learning would require that software of getting data and then turning it into an actionable information with the help of algorithms. Algorithms is something that definitely we, the lawyers, do not deal with, because this is something a kind of like scientific thing, or those who deal with the software development would know better what these algorithms would be. However, as a lawyer, we could say about the data that what that data would be, that what form of data would be given to the system, because this is something that we human future. And reasoning is against the same mechanism that has been inserted in any software, which would require that software to choose the right algorithm for the correct decision. And self-correction is something that would require the software itself to do some corrections in a case where it has in past made any errors or any system deficiency. So this is once again the same kind of the portion, the gray area where most of the lawyers we do get frustrated quite all the time that how the system would make a reasoning or what kind of mindset has been given to the software so that it would come up with any reasoning or the answer of any situation. So one of the example that the use of artificial intelligence in Pakistan is quite famous, that it made headlines in various news as well. That it was the case in the court of Sessions Court in Palia, that is in Punjab, where the additional district and session judge has decided a case. It was basically an appeal and not the trial. So that was appeal based on the situation of law, and the decision was given by using the help of Chat GPT, and that decision was given by the additional session and judge in the case of Muhammad Iqbal versus Zayad. And this made headlines quite a lot in Pakistan's perspective of using artificial intelligence and relying upon the non-human reliance on the software. It was mainly because it has never been regulated, and so that raises a question as well, as to when any situation that has not been regulated by law or by any other instrument, this software was relied upon. Unfortunately, we have seen in Pakistan and especially in our judicial scenario that quite often it happens that the judiciary do march upon things that are not being provided in the law, or ordinarily they are not being legislated. But still, we saw this decision in the appeal that was decided by the additional district and session judge in Palia, that he relied upon this chat GPT version and gave its decision over the subject matter. Whereas in other jurisdictions as well, there is a use of artificial intelligence as well. But once again, to say that it is not as ill-regulated the way we have got things out here with regards to the artificial intelligence till today. Now, there is another example of using artificial intelligence in China. We have heard quite a lot. I mean, I'm quite sure that you people have also come across to these examples and situation where we do come across and read that in different countries and different situations, the use of artificial intelligence is getting increased day by day because of its not the efficacy, but I would rather suggest that it is more of giving decisions on time, which is quite quick as compared to any human judge. So this was the case in Hangzhou Court in China, where in 2019 a software was used named as Zhao Zi, which in English would mean little wisdom. In this case, it was a case pertaining to the issue of bank where 10 people defaulted on their bank loans. Now, in ordinary situation, what would have happened that 10 different trials would have taken place. Their matter would have been dealt separately as well. However, it may be because the situation would not have demanded for the trial to go separately. So what they did is that the software that was used in this case, it dealt with 10 people in a simultaneous manner by giving a decision in 30 minutes instead of conducting 10 separate trials. So there exist these kind of examples where in different jurisdiction there are trials going on in the courts that could be used with the sole perspective that it would resolve the issues far quicker than any human judge. The main reason is only because what we have seen. First of all, we as a lawyer, if I would say about myself or for any other institution, that we have not been able to completely trust on these kind of systems, because until and unless the whole society would not come along trusting these systems, these things cannot be put in place so quickly, because first of all, we are not as self-sufficient in terms of developing these kind of technologies, or coming to know the loopholes of these technologies. However, the other countries like as earlier it has been, usually they are in charge of making all these things, but they are closely monitoring the situation as well. They are closely trying to understand that whether what kind of algorithm or what kind of bias any system could have against any individual. So these are the concerns that we are facing as of now. Because I mean, as a Pakistani, I would simply say that let alone having a kind of competency to understand, but we do not have any such advancement in our legal profession where lawyers would come up with the proper answers in situation if they have to deal with these kind of AI generated trials or appeals or anything else. So the concerns that we have prevalent as of now is divided on two basic issues, one for the lawyer and the other for the court itself. For the lawyers, there are four basic issues that have been identified, I mean, in various jurisdictions, and that is to deal with the ethics of the profession. So first would involve the principles of confidentiality. Second, the issue of competence. Third, the issue of practice management. And fourth is of honesty. Now, if we refer to the first one, which deals with the principles of confidentiality, the issue would be that once you have inserted any information of your client into any of the software which would deal with the AI generative assistance, it would automatically take away the situation of confidentiality from the lawyer itself. Because now, when the information is fed up into the machine, it is public, it is for the public. Or let's say if it is not for the public, at least it is for the software who is generating all these predictions on the basis of information that has already been given to it. Now, one of the biggest reason of being challenged with the confidentiality is that, uh, well, let's say if we are using ChatGPT, we are not in control of what ChatGPT would do with the information or how would it determine its fate in future. So we once we have inserted the information in this system, we have got hands off from this information, and the client's information has already gone into it. So that is the biggest challenge that the lawyers would be facing, whoever are using these kind of systems, in the absence where we have no legislative criteria existing, that what would happen with the situation in future. The second issue of competence, the competence is once again interrelated with the situation where we are not aware with what we have shared and what we have got in return of it. The competence of the software, as we have not seen what have been given to it, would make us think all the time whether we are competent to share this information, and then whether the situation that has answered to us by the software is also enabling us in such a manner that we could share it forward as well. And third is of practice management. The practice management mostly deals with the situation, that how we would be dealing with the situation or our work in future. Well, let's say it's very convenient by using such instruments, forums, or the softwares such as ChatGPT or any other in future to come, that would make work for us very easy. But come along with that would come even more responsibility, which we have not been able to consider or answer, that how it is going to affect the lawyers coming in future, that how would they be trained, with what they would be trained, and how things would be kept in order in any law firms. Because as compared to the developed nations, we do not have a kind of like huge chamber system in our country we could see that there are so many lawyers who are dealing with their briefs every day by not even having a proper chamber as well. They are just sitting somewhere, they are not having things in place which would enable them to manage things properly as well. Now, the fourth part, that is of honesty. Now, with regard to honesty, I would simply suggest that it deals with the arena where, for example, if you are a new lawyer and I am a senior lawyer than you, and instead of working on the things the way we are doing with it without using generative softwares, if I have developed something, how am I supposed to manage the practice for someone who is coming very fresh to me or very new at me for the work, and whether I would be honest enough to share this information with my client as well, that I have used a kind of a generative instrument for generating the situation or generating a reply of any case or for drafting any case, that I have shared their information with the software which has now made their information public. Second thing, whether I would be honest enough to share this information with the court as well. That situation for me, that as we have heard that these situations come up, that the softwares would always not give a kind of 100% answer to you. It may come up with some answer that is not honest, or it may come up with some kind of document which is totally not correct. So this would again put me in a situation where I have to be honest with the court, with the client, that I have used or relied upon a software by putting their information and not doing the otherwise, the drafting or anything else. Now, for the courts, the division is a bit different. The reason being, when it comes for the drafting of any document, mostly the courts would have to do decisions to be typed of or any order to be passed. And as we have seen in judicial system, the huge backlog of judicial system is mainly because we have got less number of judges, and the orders they have to pass is quite surmounting as compared to their availability. So the challenge that they would have to be facing would be that they would be relying on these softwares, but then who would be having a check on these orders? Well, whether the orders that has been generated by the artificial intelligence softwares, they have to go through with the whole order once again, and then they have to deal with the things once again. So which would I would suggest that would make things even worse the way they are right now. So this is one thing. The second thing is about the area of evidence. Now, this is very tricky bit. As you all would know about the Kanun-e-Shahadat ordinance, where you could see that the Kanun-e-Shahadat ordinance would require few things with regards to the evidence stage. In evidence, the one of the biggest challenge for any individual would be about having to challenge the integrity of any evidence. Now, this is something which I hope that the softwares are still not able to deal with, that they cannot deal with the authenticity of the any document or of any person. Because if we go for the documents need to be recorded by the source from where it has been presented to the court. Now, well, let's say if the source of any document is from any state department, and if that state department does not have the capacity of the statement given by any official, the court would not be able to rely on that software in that situation. It has to once again go back to the same thing and to deal with the same practice that we have, where a person would come into the court and would present the document and would explain the source of the document from which it has been made available before the court. So this is a kind of a like small review comment from Alitra BAT. She's a joint postdoctoral fellow in New York School of Law and the Digital Life Initiative. So she has been working on this has referred that unlicensed and trust and the openness of this market, I think we risk reproducing our current mistakes with big tech. Increased distance between the people making technology, and it's that every institution, be it the State Department or any private entity, they are facing is that until there is a control over such kind of softwares and the lack of regulation about these softwares, or the any law firm would face would be that when you do not have the knowledge of from where what kind of information has been fed into the software, you would not be able to understand that what answer would it be given. For that purpose, you far aware about the knowledge of the law, the way it should have to be done by the software. I mean, you have to be two step ahead of the software, which would even require more, a kind of a tough regime for the lawyer to adopt, so that it could understand that whatever the decisions or the predictions has been generated by any AI source, that it is reliant and could be used in the court of law as well, and could be the information that is actually meeting the needs of your client as well. Because if you would ignore your client from this picture, you would not stand anywhere. You would not be able to deal with any situation, because if you write something, if you give a command that is not meeting the needs of your client's issue, certainly it will hurt you not only financially but reputational wise as well. So before using any such software, it is important for even for the Pakistan as well, that before introducing or the way judges are using this information, the regulation should be made in a way that we could be very much satisfied with the fact that whatever the answer or the prediction has been given is one that is regulated by the law, and there is an independent check on these softwares as well, that no such illegal things or the wrong things are being made out of it. So let's say if we have adopted to the artificial intelligence, so there would be future questions that we as a lawyer would be thinking on our side, that what it would be, that how the landscape would be for. So the second situation was dealing with the things. Well, let's say one of the biggest market work or the market area for any lawyer in this country, because there's a division of work in two situations. First, you get work from the independent client. Independent client means you have got like walk-in clients or private organizations or the institutions, they give you work. The other aspect of work is you get work from the state departments, and that is heavily reliant from many lawyers, situation chances or equal opposition. And once when you see that these kind of softwares have been deployed for the work, it may happen that the situation for discriminatory behavior might increase until and unless it is properly regulated as well. And mental health is something I'm not too sure whether how many of you would know that what is the situation of, or what is the mental health for the lawyers. This is something, this is a term that is not quite we have been discussed or we have been taught anywhere or even in practice as well. Nobody care about the mental health of lawyers, that how the stress would come upon the lawyers and how things would be dealt with. And once again, in this arena, the regulations, we don't have any proper answer as well. Even in the manual life, we do not have any kind of regulation or support system that could deal with the health, mental health issues of lawyers. But still, this is one more issue that would be dealt with the lawyers as well. So whether the opportunity for new aspirants or junior lawyers would remain the same? No, I don't think so. It will not remain the same. The reason being that in ordinary situation, when any new lawyer or a junior lawyer assume the office or join any office, what it happens that they are being taught in a very different manner, in a very different environment. And the mentorship that has been, well, I would know that most of you would not agree that there is a mentorship situation or a scheme properly going on. But still, whatever kind of mentorship is given would completely change. What it would make most is that the lawyers would have to deal with the junior lawyers or the new lawyers in a way that they have to be very vigilant in teaching them how to use the commands for getting a right answer from any artificial intelligence system, which I would think that would affect the junior lawyers and the new lawyers until and unless the senior lawyer himself or herself is quite capable or has gone through with the path of learning this thing first, and then the junior lawyers are being taught in the proper manner. So, with regards to the instruments at various levels, internationally, the United Nations has developed a framework that has been adopted by almost 193 states across the world, in which they have gone with the UNESCO's argument of adopting a framework which would require. I mean, this is a framework which was adopted by 193 countries, and a rule which has been taken up by the Resolution 37, pursuant to Article 40 of the UNESCO Constitution. They have come up with the draft. They have come up with the draft that there is a technological concern that we need to address, and it need to be addressed in a way that first they have to accept that the artificial intelligence has taken over with the things. This is a situation that cannot be overridden or ignored purely because we don't like it. We have to accept it that this is the thing that is in place, and the world has to deal with it because and when it comes to the legal situation, not only the situation would come that you have to deal domestically, but in case you have to deal with international level, the legal requirements has to be fulfilled. And for that reason, I think this framework would be very important to deal with in future to come. Whereas the United Nations has still warned about the technological challenges that we would become. That was given in the same framework statement by saying that we see increased gender and ethnic bias, significant threats to privacy, dignity, and agency, dangers of mass surveillance, and increased use of unreliable intelligence technologies in law enforcement. To name a few, until now, there was no universal standard to provide an answer to these issues. So, the gray area that has been referred by the host of this today's session was not false. That is based on truth because there is so much to be done before completely letting these machines to take over the human presence in this regard. Apart from United Nations, the regional organizations such as the European Union, they have recently passed an act about uh, it's called as European Artificial Intelligence Act 2021, which has recently been adopted by the member states and has been accepted by many European Union's countries that there has to be an act in place which should deal with the situation. Now they have divided the risk in this act in various categories. So the first is to ensure better condition for the development and use of technologies is a risk that is unacceptable at any level. That is, systems that are considered as threat to people will be banned. Cognitive behavioral manipulation of people or specific vulnerable groups, social scoring, biometric identification and categorization of people, real-time and remote biometric identification such as facial recognition. Now, this is the category they have taken out very seriously by not being allowing any software to develop on its own. If any of the software which will go against the situation, they will simply ban it. So, cognitive behavioral manipulation of people or specific vulnerable groups. Well, for example, in European Union, we could see that there are societies or there are groups of people who live there. For example, let's say if there is a bias against any specific Muslim group, or if there is a bias against any group that is identified in the basis of color. In Europe, you do come across this term that they refer to the societies from their races and their color as well. And if there is anything that is to deal with the social scoring or the biometric identification and categorization of people, biometric is something that you might have also seen in the major urban cities by yourself as well. Well, for example, if you go and buy any mobile phone SIM, you see there are people sitting on the street as vendors of these mobile SIMs. They would take your biometric on the streets without having any kind of authority, without having any kind of permission or any security of the data they would store with them. No one knows where this data would be secured, or who and where this person would be using your biometrics or any other situation. So such kind of softwares, they would be completely banned immediately, as they would be considered as an acceptable risk. The second category is of the high risk. High risk has been connected with the safety of with anything that affect the safety of any individual, or if anything that violates the fundamental rights, and that would be considered in the category of high risk and would be banned as well by way of having a check on it. So the first thing is, because they have divided these categories into two categories. AI systems that are used in products falling under the EU's product safety legislation. This include toys, aviation, cars, medical devices, and lift. For example, we could see the use of drone in the present day. We have seen how much it has been increased. And recently, in the war in Ukraine, we have seen that the such drones has been used on doing attacks by the Russian military on the Ukrainian installations and their civil infrastructure. So they have kept that thing in their mind as well, that in future, if they are going to use any such technology that would be hazardous to the safety in the form of these things, and that would be banned as well. Second situation is any AI system falling into a specific area that will have to be registered in an EU database, management and operation of critical infrastructure, education and vocational training, employment, worker management and access to self-employed, access to and enjoyment of essential private services and public services and benefit law enforcement, migration, asylum and border control management, assistance in legal interpretation and applicable of the law. So, and the another category, that is the general purpose and generative AI. Generative AI like GPT would have to comply with transparency requirements. Disclosing the content was generated by AI, designing the model to prevent it from generating illegal content, publishing summaries of copyrighted data used for training. Now, this is once again the same situation that we are discussing. That as being a lawyer, I mean, in our situation, in our jurisdiction, where we see if we have generated any document with the command of AI chat GPT kind of software, if we do not disclose it, that it would create an issue of confidentiality. It will raise an issue of honesty and not telling the court that how this document has been generated. So this has been made law in the European Union, that they have to disclose and they have to make it clear that it was generated by the artificial intelligence document. because in return it would create an obligation upon the same user of the software, that since the document has been generated on your command, so you would be taking liability of any error or omission that has been found later on in the document. In case if the situation of misleading the code is to be found, that would be done on the shoulders of the person who has generated any document. And at the end, it is the limited risk. The limited risk AI system should comply with minimum transparency requirement that would allow users to make informed decisions. After interacting with the applications, the user can decide whether they want to continue using it. The user should be made aware when they are interacting with the artificial intelligence. This includes AI systems that generate or manipulate image, audio, or video content, for example, deepfakes. Now, this situation we have seen quite often when we make any orders through online, I mean, for food from Food Panda or from anyone, you would see that, or any other, I mean, I'm not too sure whether you Food Panda would use these things or not, but there are few applications where you could see that you would get an automated responses from any software. So this is referring to that kind of software where people need to be made aware of the fact that who they are dealing with. And if they are dealing with the AI interface, they have to be made aware of the situation that you are dealing with the AI thing. So in this situation, the way we have seen this example, it's very, very basic as of now to say that we would be going onto these kind of things very early. Until and unless we do not have a regulation in place, I don't think it would be appropriate for any of us to rely or to even use these documents, because whatever we would be producing, there would be a risk of having something done or getting anything that is not credible, or something that is that could not be certified by anyone. So this is what the basic what I wanted to have a discussion with you, and I hope you might have find this information a bit of a valuable.